Hello, everyone. My name is Martha Roberts. I am the director of the Washington, D.C. office of the Institute for Policy Integrity at NYU Law School. Thank you all so much for joining us today. We are now a little over 1 year into the Trump administration, and I'm sure everyone would agree that each day is a fire hose of news, rollbacks, new announcements, a constant stream of assertions and statements and memos from the administration. It's hard to keep track. It's easy to feel overwhelmed. But if you take a step back, you can find trends, you can find common tactics, and patterns start to emerge. Importantly, this makes it easier to look strategically over the landscape and understand what is happening, understand what is a major development and what is just noise, and better decide where you should spend your limited time, energy, and attention. This webinar is designed to do just that. Importantly, looking at just issues in the rulemaking regulatory space. Of course, there are very important developments beyond this arena, but today here we're just going to be focused on rulemaking and regulatory developments. My colleagues will each walk through a repeated tactic or line of reasoning we've seen the administration apply as it is sought to roll back and repeal existing safeguards. In each case, we'll give a brief presentation of what the tactic is, what we've seen happen, and then we're going to walk through a legal analysis of the practice. That is it legal? Here are the topics that we are going to cover today. My colleague Bridget is going to look at bare bones repeals, where the administration is seeking to repeal rules with no meaningful supporting analysis. My colleague Dina will cover the pattern of rulemakings that include only a flawed or one-sided analysis. My colleague Kate will address an aspect of that phenomenon, specifically rulemakings where the analysis is ignoring major impacts. My colleague Jack will look at instances where the administration has deemed certain rules supposedly unlawful and has sought to repeal them with expedited processes on that basis. My colleague Gabe will look at the pattern of foregoing any public comment in rulemaking repeals. Jason will address rule sunsetting, where the administration has sought to have rules automatically end or sunset after a given period. Lastly, my colleague Max will give a picture of the current litigation landscape. And we will leave time at the end of the presentation for Q&A. Before we dive in, I want to flag 2 items. So first, I want to note that this discussion distills insights from more detailed issue briefs that are all available on the Policy Integrity website. The website address is here on this slide. This same website also hosts our regulatory tracker, where we are tabulating and highlighting the lost benefits from rolled back protections. So those are all available on the website that's listed on the slide. Second, I want to note that we are pleased to offer CLE credits for joining this webinar. If you would like to receive CLE credits, I want to call your attention to a CLE affirmation form that you should have received via email. If you may have missed that email, we will also be dropping that link to that form in the chat. In order to receive CLE credit for joining today's webinar, please make sure to fill that form out, including the CLE password, which we will share later in the presentation. So we have a lot of topics to cover today. So without further ado, I am going to pass it on to my colleague, Bridget, who will dive in on bare bones rescissions.
Hi, everybody. Thank you so much for joining us today. As Martha said, my name is Bridget Pals, and I'll be talking about what we've been calling bare bones rescission. So before we dive in, I wanted to highlight an issue brief that Max and I wrote called Rescissions Without Reason, which covers all of these issues if you're interested in learning more. So what are bare bones rescissions? Bare bones rescissions are deregulatory actions that are accompanied by little or no agency reasoning. So for example, last May, the Department of Energy, or DOE, sorry, there's a loud fire truck. I hope not everyone can hear that. As I was saying, last May, the Department of Energy, or DOE, released a slew of proposed rules weakening energy and water efficiency standards. In many cases, with no further elaboration or analysis, the agency simply stated that, having reconsidered the standard, it now finds it economically unjustified or unnecessary. Full stop. This isn't normal. Typically, such proposed rules would have long technical analyses estimating the costs and benefits of the proposal, including, for example, the anticipated consumer savings or increased consumer costs from those changes. This analysis would also include analysis of alternative standards, like a more or less stringent efficiency standard. These DOE proposals, however, offered no analysis, weighed no alternatives, and provided essentially no insight into the government's decision-making process. So the question is that legal? We say no. These bare-bones rescissions give rise to a number of possible legal claims, which we'll take one at a time. So first up, these proposed rescissions don't give the public adequate notice because they don't explain the agency's rationale. The Administrative Procedure Act, or APA, requires agencies to provide notice and an opportunity for the public to comment. Adequate notice, according to at least 4 circuit courts of appeals, means an agency must disclose in detail the thinking that has animated the form of a proposed rule and the data upon which that rule is based. Now, if an agency provides only its decision and not its rationale, the public can't meaningfully comment because it doesn't know how the agency thought the evidence supported its policy choice. Bare-bones rescissions almost definitionally fail to give adequate notice. Many of DOE's proposed rescissions offered essentially no reasoning, and where there was a rationale, it was really slim and not backed up with any evidence. So, for example, DOE said that weakening a water efficiency requirement for a clothes washer was justified because the current standard required an undesirable longer wash cycle. But DOE didn't support that claim with any evidence, let alone show that getting a shorter wash cycle was worth foregoing the billions of dollars in consumer savings associated with the status quo standard. Because the public hasn't really been given a clue as to DOE's rationale for making these standards, it therefore can't be said to have had adequate notice. Next, we'll consider ways in that a final rule that stems from a bare-bones rescission might be flawed. So as a threshold matter, a bare-bones final rule would clearly be arbitrary and capricious. The Supreme Court has long held that an agency must provide a rational connection between the facts found and the choice made by an agency. Conclusory statements are not enough. And when repealing a rule, an agency must also provide a reasoned explanation for disregarding facts and circumstances that underlay the prior policy. In other words, an agency can't simply ignore inconvenient facts from its prior rulemaking. It must address them. A bare-bones final rule in line with the bare-bones proposals we saw last year would necessarily fail this test because it would contain only conclusory statements and fail to engage with the facts and circumstances underlying the original policy. Now, you might wonder whether an agency could sidestep this problem by simply following up a bare-bones proposal with a final rule that does have a complete analysis. But doing that would run into another type of procedural error, a violation of the critical factual material doctrine. That doctrine, which has been adopted by 5 circuits, including the DC Circuit, requires that an agency generally make available for comment technical studies and data that it relied upon in making its decision. Failure to make such studies available for comment can amount to serious procedural error. Now, there are some exceptions to this rule for data, for example, that was added at a later stage, but is only supplementary to data that was already included at the proposed rule stage. But we'll keep that to the side of this discussion. Now, in order to make a non-arbitrary and capricious case for rescinding its formal standards, DOE would likely need to introduce new studies that support rescinding the former standard. But such evidence then would likely be critical factual material that requires public comment. So if DOE chooses to bolster its reasoning with evidence to sidestep the arbitrary and capriciousness problem we already discussed, it likely needs to offer an opportunity for comment. And finally, a final rule that doesn't consider reasonable alternatives would also be arbitrary and capricious. As a general matter, agencies must consider reasonable alternatives to their proposals. In the context of a regulatory rollback, the Supreme Court has explained that an agency should consider alternatives within the ambit of the existing standard, short of a full repeal. So, for example, this could mean considering a less stringent standard or only eliminating part of a rule, but not the entire policy. The bare-bones proposals that we've seen offer no alternatives. A final rule that did the same could be arbitrary and capricious. We've just talked a little bit about some of the legal vulnerabilities that arise when an agency issues a proposed rule or final rule without providing any reasoning or analysis. Next up, my colleague Dina Adler is going to tell you a bit about what happens when an agency produces an analysis, but the analysis is flawed.
Thanks, Bridget. Good afternoon, everyone. I'm Dina Adler. I'm a senior attorney here at Policy Integrity. So Bridget helpfully took us through the issues with bare bones analysis, but what about the cases when an agency goes beyond that admittedly low bar? Over the past year, we've observed a pattern of flawed or incomplete analysis that either leaves out important effects or analyzes them improperly. We're seeing this trend implemented through both the regulatory analysis of individual rulemakings. Sorry, I'm just starting my video. And through changes to executive guidance that encourage this type of improper analysis. For example, last February, the OMB issued a memo officially rescinding updates made during the Biden administration to a core guidance document for federal regulatory analysis known as Circular A4. This document guides federal agencies on assessing the benefits and costs of significant rules. The result was reverting to an older form of Circular A4 from 2003. Among other things, that meant eliminating updates to the recommended discount rates, that is, the rate at which future impacts are translated into their present values. Reverting to the older discount rates disproportionately affects the analysis of public health and environmental benefits because many of these benefits are felt far into the future, while the costs of pollution control are often higher in the near term. So under the memo, OMB reverted to recommending 3% and 7% discount rates rather than 2%. Now that may not sound like a big deal, but the effects can be quite significant. For instance, a policy that would have yielded a $100 million benefit in 30 years undiscounted would be valued at $55 million at the 2% discount rate, but only $41 million at a 3% rate or $13 million using a 7% discount rate. So it can seriously skew the cost-benefit ratio to revert to the older discount rates. As I'll discuss further in a few minutes, Policy Integrity put out a report explaining the legal flaws with the rescission of Circular A4 and the use of the outdated discount rates more generally. Looking beyond the guidance documents, and beginning with a first wave of proposed rules that came out early last summer, including repeals of the carbon pollution limits for power plants and the mercury and air toxic standards updates for power plants, we began to observe a pattern of limited analysis that included reversion to the old discount rates, as well as functionally eliminating consideration of key climate effects by declining to monetize those effects, a failure to update modeling, and the baseline for regulatory analyses. Since the summer, we've observed additional errors, including different types of inconsistencies and analytical assumptions, and functionally eliminating consideration of additional categories of foregone benefits from repeals and delay rules. Notably, one trend we've observed is a failure to properly consider foregone benefits from reducing particulate matter and ozone air pollution by not monetizing the health effects and premature mortalities from these emission reductions. We first saw this in a new EPA rule in January that revised emission limits for nitrogen oxide pollution from new gas burning turbines used in power plants, and it turned decades of EPA practice on its head. And notably, we're seeing errors more broadly than just the environmental sphere. For example, there was an HHS rule repealing minimum staffing requirements at long-term care facilities that emphasized cost savings while overlooking extensive foregone benefits. So, is all of this legal? Next slide, please. It's important to consider on a case-by-case basis, but generally, no. Deregulatory actions are bound by the same obligations for reasoned decision-making as regulatory actions. Going back through decades of implementing the Administrative Procedure Act to the review standard laid out by the Supreme Court in its 1983 State Farm decision, a court may find an agency action arbitrary and capricious if the agency entirely failed to consider an important aspect of the problem, such as the costs and benefits that should properly be part of a regulatory analysis. An agency must also provide a reasoned explanation for disregarding facts and circumstances that underlay or were engendered by the prior policy. That's according to a standard from a 2009 Supreme Court case, FCC v. Fox Television. Now, given that the Biden administration rules were built on comprehensive records, the repeals would need to do a fair bit of work to rebut those extensive records. And often we're seeing repeals that have not treated those earlier records carefully. And so when an agency also fails to update its analysis or ignores effects from these earlier records without adequate explanation, it's difficult to say the agency has given a good reason for changing course on its policy. Policy Integrity released a report called Flawed Foundations, in which we explain in more detail how these principles apply to regulatory analyses of deregulatory actions. But at heart, when an agency ignores the foregone climate or public health benefits of a repeal, it is violating these principles. An agency is not permitted to cherry pick from the different costs and benefits in the original rule or put a thumb on the scale by under or overvaluing key effects. That means that an agency cannot consider only the cost savings of a deregulatory action without also considering the lost benefits of reversing the original rule. The Supreme Court made clear in Michigan v. EPA that regulatory costs encompass any disadvantage from a rule, including, for instance, harms that regulation might do to human health or the environment. A difficulty in monetizing or quantifying effects on one side of a ledger is no excuse for lopsided analysis that ignores these effects. And an agency must consider both the targeted effects of the regulation as well as other important effects or co-benefits. Just this October, OMB put out a new memo on streamlining deregulation in which it re-stressed the standard from Michigan v. EPA that all relevant factors must be considered, including both the costs and benefits. So that's a standard we would like to see embraced. In a few minutes, my colleague Kate Welty will do a deeper dive into some of the examples of ignoring key climate and public health effects and explain why uncertainty is no bar to considering those effects properly or a good reason to reverse course from prior agency policy. But before we turn to her interesting remarks, I have one more slide to cover. And here, the main takeaway is that a key part of considering all important effects is to analyze each of the effects properly. A failure to analyze an effect properly can dramatically change the assessment of the size of the effect and alter the cost-benefit ratio. And thus, it frustrates the ability to consider all the important components of a problem. These errors can come up in different places, including the choice of the discount rate. As mentioned, Policy Integrity issued a report that unpacks both the legal errors with the guidance rescinding the updates to Circular A4 and using the old discount rates more generally. First, reversion to old Circular A4 is likely unlawful because by statute, any update to OMB's guidance on benefit cost analysis requires peer review, which was not undertaken here and would likely raise concerns with the rejection of recent analytical developments and updated data. Separate from the guidance, agency actions must still be based on reasonable analysis. And this means that relying on outdated analytical practices from the 2000 Circular A4 could very well fail that test and block the agencies more generally from reverting to the outdated discount rates. Specifically, where the 2003 Circular A4 derived its 3% discount rate by averaging real inflation-adjusted rates of return on 10-year Treasury notes from the 30 years beginning in 1973, the 2023 update to Circular A4 did the same for the 30 years beginning in 1993. It's hard to find a good reason to use data that's 20 years stale. Turning next to baselines, to accurately consider the anticipated effects of a policy, an agency must differentiate the effects of the policy from future changes that will occur regardless of the policy. An agency does that by setting a proper baseline. Expectations about the status quo without the rule may have changed by the time the rule is being repealed. For example, there may be changed expectations about energy demand in the power sector. Courts have recognized that a baseline using outdated or inaccurate information can lead to arbitrary decision-making because it affects the estimation of the effects. an agency needs to explain if that update is not needed. Turning from baselines to inconsistencies, the choice of baseline can lead to another type of inconsistency when an agency provides a rationale for a repeal, like rising energy demand or declining electricity reliability, but it does not integrate that change through updated modeling or an update to the baseline. It then becomes difficult for an agency to justify that a change is too insignificant to require a baseline update, but also is so significant as to necessitate the repeal action. That came up in a rulemaking to delay the compliance deadline for effluent limits from power plants. Also, during the first term Trump administration, there were other instances where an agency assumed that cost savings would be realized from delaying an action, but then said there would be no foregone benefits from a delay because the delay didn't change the pre-delay status quo, and that's an impermissible double standard. So with all of that as background, I'll now pass the mic over to my colleague, Kate, to take us deeper into some examples.
Hey everyone, my name is Kate Welty and I am a legal fellow here at Policy Integrity. Thank you, Dina, for running through some of the major analytical flaws we're seeing in rulemakings from this administration. I'm going to hone in on a couple errors that we're seeing agencies make that particularly skew assessment of environmental rules to undervalue the benefits of pollution control. And to do so, I'm going to use the recent rescission of the endangerment finding and associated repeal of the vehicle greenhouse gas standards as a sort of case study. Now, the first analytical maneuver I want to highlight is the decision to stop monetizing the climate effects of rules. For some context, in May 2025, the Office of Management and Budget released a memorandum calling on federal agencies to cease using social cost of greenhouse gas values in their analysis. The social cost of greenhouse gases is used to monetize the cost per unit of greenhouse gas emissions and has been used by the federal government for almost 2 decades to inform regulatory decisions that affect climate change. In 2023, EPA published an updated set of social cost of greenhouse gas values based on latest updates in climate science and economics. And those estimates suggest that 1 metric ton of carbon dioxide emitted in the year 2025 causes around $252 in global climate damages. It's important to note that this number is likely an underestimate due to the omission of many key climate damages from that metric. And yet, in its May 2025 memo, OMB suggested that the social cost of greenhouse gases is too uncertain to use, despite the fact that it is based on rigorous science and economics that have withstood peer review. For more on the social cost of greenhouse gas values and OMB's reluctance to use them, I'd urge you to check out Policy Integrity's issue brief, Zero Rationalities, which explains the basis for these values and unpacks some of the flaws in OMB's argument for ceasing use of this metric. Now, many agencies have adopted OMB's guidance, but I want to highlight its effects on EPA's recent rule rescinding the endangerment finding. As many of you likely know, the endangerment finding refers to the 2009 finding that greenhouse gas emissions from motor vehicles contribute to dangerous air pollution. This finding was the scientific predicate for over 15 years of EPA rules limiting emissions of greenhouse gases from cars and trucks. A few weeks ago, EPA finalized the rule repealing this finding alongside all motor vehicle greenhouse gas standards. Now, this repeal is obviously going to result in significant increases in emissions of air pollutants, including greenhouse gases. But in its rule, EPA adopts OMB's guidance and declines to monetize the impacts of these increased emissions, noting that the federal government is no longer using the social cost of greenhouse gas values for the purposes of estimating costs and benefits of its actions. In doing so, EPA effectively values the climate damages of its rule as zero because it provides no alternative for measuring these damages. And these climate damages are something that we will all feel personally, including higher costs for healthcare, insurance and food, property damage, and even mortality. This omission is particularly astounding given that estimates suggest that the climate costs associated with repealing these standards are in the ballpark of around $2 trillion, far exceeding the $1.3 trillion in projected benefits of the rule. By ignoring these damages, EPA has dramatically upset the weighing and costs and benefits of its action. The second analytical move I'd like to highlight has a similar flavor. Alongside its decision not to monetize climate effects, EPA has also begun declining to quantify or monetize the expected public health effects associated with increased emissions of other air pollutants, like particulate matter and ozone. As Dina mentioned, we first saw this in a rule easing emission standards for certain gas turbines, but EPA again adopted this strategy in the endangerment repeal. Here too, EPA cites uncertainty as a reason for not estimating these effects, suggesting that the methodology the agency has used for decades to calculate these impacts actually results in a false precision to the public. EPA does not provide an alternative methodology for estimating these effects, and so effectively renders these effects, which include thousands of early deaths and millions of additional asthma attacks per year, as meaningless. In contrast, EPA's newfound unwillingness to consider what it considers to be uncertain impacts, we're also seeing agencies who are willing to consider those speculative impacts when those impacts are cost to industry. For example, in the proposed repeal of the National Highway Traffic Safety Administration's fuel economy standards, the agency adopted uncertain assumptions regarding how auto manufacturers would deal with performance loss that bolstered the estimated benefits of repealing the standards. And third and finally, a related but separate trend we're seeing from EPA is to slice and dice effects such that no effect seems significant in isolation. This is something we've seen in EPA's proposed repeal of the greenhouse gas emission standards for power plants, as well as the endangerment repeal. In both rulemakings, EPA has suggested that a source's contribution to global climate change is so insignificant such that it renders its emissions de minimis and not worth regulating. A quick dive into the numbers suggests this argument is clearly irrational. For example, in the endangerment repeal, EPA suggests that regulating greenhouse gas emissions from cars and trucks would be futile because emissions from these vehicles have no material impact on global climate change concerns. But the US vehicle sector is the highest source of transportation emissions globally. And over the last 50 years, US vehicles have emitted more greenhouse gases than the vehicles in the next 9 highest emitting countries combined. Emissions from US vehicles cause billions of dollars in economic damages to the US alone and will result in loss of thousands of US lives. And in prior Clean Air Act rulemaking, EPA has routinely regulated sources with emissions that comprise a smaller share of a larger pollution problem. Now, the question of the day, are these analytical moves legal? The answer is probably not. Matt, could we go to the next slide? So these maneuvers have helped agencies minimize the significant cost of their regulatory decision. They violate several fundamental principles of reasoned decision-making that Dina already outlined. By citing uncertainty as a reason to no longer consider climate and other public health costs of its repeal, EPA is in fact leaving significant effects out of its regulatory analyses. In 2008, the Ninth Circuit held that it was arbitrary and capricious for NHTSA to assign zero monetary impact to a change in greenhouse gas emissions that resulted from an agency's policy change. And it's hard to see how EPA's analytical decisions in the endangerment repeal are any different than that. Further, in choosing not to value these impacts, EPA does a woeful job explaining why it walks away from existing analytical frameworks, including the social cost of greenhouse gases and the methods for monetizing impacts of particulate matter and ozone that have been used by the agency for years. And by being willing to include uncertain industry benefits in its analysis while ignoring other significant costs, agencies are improperly tipping the scales of their benefit cost analyses. Next up, we're going to hear my colleague Jack Jones explain more about agencies' repeals of supposedly unlawful rules.
Thanks so much, Kate. And hi, everyone. I'm Jack Jones, a legal fellow here at Policy Integrity, and I'll be discussing agencies' repeals of supposedly unlawful regulations. So the presenters before me have discussed issues with inadequate analysis in deregulatory rules, and I'll be talking about a trend in agencies' legal rationales for rescinding existing rules in the first place. So last April, President Trump issued a presidential memorandum, which was titled Directing the Repeal of Unlawful Regulations. And that memorandum instructed agencies to rescind existing regulations that conflict with 10 recent Supreme Court decisions, including prominent administrative law decisions like Loper-Bright, which overruled the Chevron doctrine, and West Virginia versus EPA, which announced the Major Questions Doctrine. And 2 subsequent memos from the Office of Management and Budget offered further guidance to agencies on how to implement this presidential memorandum. So the first OMB memo, which was issued last May, listed factors from each of these cases that agencies should consider when evaluating whether existing regulations conflicted with these Supreme Court decisions. But the OMB's summaries of these Supreme Court cases offered very broad interpretations of these cases that frequently misrepresented or stretched the holdings. And my colleague Max Zorinsky and I actually responded to some of those interpretations in the issue brief that's shown on the slide. And we explained what aspects of these cases the OMB memo misrepresents. So as an example, OMB's characterization of Loper-Bright was very misleading. Loper-Bright overruled the Chevron doctrine, which, as I'm sure many people on this call know, was a legal doctrine that permitted courts to accept agencies' interpretations of vague or ambiguous statutory language as long as the agency's interpretation was reasonable. And Loper-Bright, in overruling Chevron, instructed courts to no longer defer to agencies' interpretations of statutory language and to instead determine themselves the single best meaning of statutory language. So OMB's memo tells agencies to consider, under Loper-Bright, whether a regulation is consonant with the single best meaning of the statute authorizing it, with particular focus on any regulation that was promulgated in reliance on Chevron and that could be defended only by relying on Chevron deference. But this is misleading. In Loper-Bright, the Supreme Court was actually very careful to clarify that its decision did not call into question prior cases that relied on the Chevron framework to uphold rules. So court decisions upholding agency actions under Chevron actually remain good law, which means that agencies are not compelled to rescind or modify those regulations, even if the existing regulations don't reflect the best reading of the statute. Matt, can we move on to the next slide? So that covers some of the instructions that the President and the OMB initially gave to agencies on how to go about repealing supposedly unlawful rules. So moving on to what agencies have actually done in response to these directions. When repealing existing rules, agencies have often cited Loper-Bright, or sometimes West Virginia, to argue that a rule is unlawful. And so as a result, they must rescind it, even in situations where a court has previously upheld the rule. So a great example of this is the Fish and Wildlife Service's proposed rule last year to rescind the regulatory definition of harm under the Endangered Species Act. So the Endangered Species Act prohibits the take of any endangered species, and the statutory definition of take includes the term harm. And decades ago, the Fish and Wildlife Service issued a regulation providing a further definition of the term harm, and included acts of significant habitat modification that kill or injure wildlife by impairing with behavioral patterns like breeding, feeding, or sheltering. And this interpretation was upheld by the Supreme Court in 1995 in a case called Babbitt versus Sweet Home. But last year, the Fish and Wildlife Service proposed to rescind that regulatory definition of harm and argue that under Loper-Bright, the regulatory definition does not match the single best meaning of the statute because the statute does not use the term harm in the service's argument to encompass indirect harms like habitat modification. And as support for that argument, the Fish and Wildlife Service cited Justice Scalia's dissent in the Sweet Home case from 1995. And the Fish and Wildlife Service goes on to claim that because the rescission of the regulatory definition is compelled by the best reading of the statutory text, in their opinion, that it is therefore a non-discretionary action in which the agency does not have authority to consider otherwise relevant policy or factual issues, such as the repeal's environmental effects. But this reasoning is wrong. The regulatory definition remains good law under the Sweet Home majority opinion, and that means that the rescission is not legally compelled. In other words, the agency has the option of lawfully maintaining the current regulatory definition because it was upheld by the Supreme Court, but instead it has voluntarily chosen to rescind it. So because it is choosing between two lawful options, its action is not non-discretionary. And regulatory rollbacks such as this one, based on a theory that an existing rule is unlawful and must be rescinded, are basically taking a risk. On the one hand, they're vulnerable to litigation challenges, particularly in situations like the Endangered Species Act harm definition rule, where the agency is upsetting existing judicial precedent. But on the other hand, if the agency wins in any litigation challenging this regulatory rollback, it may actually lock in its interpretation of the statute if the court finds that the agency is actually correct, that it does not have the authority to maintain the existing rule. And so a ruling like that could limit the agency's authority to reissue a similar regulation under a future administration. So in October of last year, the OMB followed up with a second memo offering further guidance to agencies in implementing the Directing the Repeal of Unlawful Regulations presidential memorandum. And this second OMB memo really doubled down on this theory of agencies having a non-discretionary duty to immediately rescind rules that they believe are unlawful. And that memo basically tells agencies that where they believe an existing rule is unlawful, they should immediately repeal it, often skipping normal procedural requirements like notice and comment, and without performing the full deliberation and consideration of alternatives that an agency must normally satisfy in order to issue a rule. And Matt, can we go to the next slide? Okay, so the big question is this legal? Is the administration's theory of a non-discretionary responsibility to fully repeal supposedly unlawful rules without normal process correct? Our answer is no. Even if an agency is correct that a rule is unlawful, the agency is actually still required to rationally consider alternatives to fully rescinding the rule, which could include things like a partial rescission rather than a full rescission where that's possible. And agencies must also consider any serious reliance interests in the existing rule before rescinding it. And in fact, they may choose to delay or otherwise alter a rescission in light of reliance interests, even where the rule is in fact unlawful. And that was clearly held by the Supreme Court in 2020 in a case called DHS versus Regents. And so as a result, any rescission that properly considers reliance interests, as it must, is at least partially discretionary, and the agency must provide its analysis of the reliance interests that it considers. Agencies also must generally provide for notice and comment unless a specific narrow exception applies. And that's an issue that my colleague Gabe Levine will be discussing in more detail in just a moment. And so any agency actions that disregard these considerations are unlikely to be lawful, even where the agency is actually correct that the existing rule that it is repealing is unlawful. And again, my colleague Max Zorinsky and I wrote an issue brief on this topic, which is shown on the slide. And finally, I just wanted to end with what might be an obvious point, which is that just because an agency has concluded that a rule is unlawful does not mean that that conclusion is legally correct. So if an agency has misinterpreted the relevant statute, then its rescission may be unlawful, regardless of whether it observed the normal procedures of rulemaking or not. All right, and with that, I'm going to hand it off to Gabe, who is going to talk about agencies foregoing public comment in rulemaking.
Thanks so much, Jack, and to all of you for being here. My name is Gabe Levine. I'm also a legal fellow here at Policy Integrity. I'd like to take this opportunity to remind you all that you're welcome to submit questions or comments into the Q&A, which we will address if time permits at the end of this presentation. So my colleagues have talked about some of the shortcuts, both procedural and substantive, that the Trump administration has taken in rulemaking. And what I'll be discussing is how the administration has also sought, in some cases, to forego the basic rulemaking process altogether. So, as we've heard throughout my colleagues' presentations, public notice and comment really is at the heart of the federal rulemaking process, as many of you on this call may well know from personal experience. When an agency wants to make or repeal a rule that carries the force of law, it must publish a proposed rule, in most cases, one that discloses the critical factual material underlying the agency's reasoning, and then give the public a meaningful opportunity to participate through written comments. After that comment period, when the agency issues a final rule, it has to respond in writing to significant comments, including comments raising the very kinds of issues about uncertainty or illegality or reliance interests that my colleagues, again, have discussed. Now, the Trump administration has been trying to move away from this baseline, especially when it comes to deregulation. Last spring, a presidential memorandum and subsequent guidance from the Office of Management and Budget directed agencies to repeal rules that the administration considers unlawful, not through the normal notice and comment process, but by simply rescinding them without public comment. The theory, roughly speaking, is that if a rule is unlawful to begin with, there's no need for public input on removing it. And more generally, the agency has also sought to forego public notice and comment in other contexts. Now, later that year, in October, OMB issued a follow-up memo suggesting that agencies weren't doing enough, that in the memo's words, quote, agencies do not appear to be fully maximizing their energy in carrying out the president's deregulatory directives, fully maximizing their energy being in quotes. Unlike some of my colleagues here, and again, some of you on this call, I personally have not spent time in the federal government, but I take this to be bureaucraties for something like get with the program. And from the administration's perspective, it seems there was good cause, so to speak, for issuing that follow-up memorandum in October. In tracking the administration's deregulatory actions, we've seen that most rules are still going through the normal process. Agencies are departing from standard procedure more often than they used to, and in some cases in very aggressive ways, as I'll discuss, but apparently not nearly as often as the White House would like them to. Now, this is suggestive, perhaps, both of the actual value of notice and comment for improving the rules that the federal government puts out, but also of some of the legal risks that agencies incur when they bypass those normal procedures. And it's to that risk that I'll now turn on the next slide. So what are the legal theories that the administration has invoked to justify foregoing notice and comment, and how do they hold up? We've seen, you can slice and dice this in different ways, but we've seen basically three categories. So the first is what's called the good cause exception to the Administrative Procedure Act's notice and comment requirements. The second is a set of subject matter specific exceptions that are also built into the APA. And the third, a little bit fuzzier, is a practice of shortening public comment periods rather than eliminating them altogether. So I'll start with the first, good cause. So this is the broadest one, and it's also the one that the administration has invoked most frequently in its rulemakings. The APA allows agencies to forego notice and comment when an agency finds for good cause that doing so would be, and I quote, unnecessary, impracticable, or contrary to the public interest, unquote. And historically, this exception has been invoked narrowly, and courts have insisted that it only be invoked narrowly. So for example, we see agencies historically finding good cause where you have a scenario where pre-publication notice would just defeat the purpose of the rule because agency wants to make sure that everyone is complying at the same time. And this is an issue, this good cause exception, which has been so important to the administration, is something that my colleagues Jack and Max, working with an NYU law student, explained in the issue brief on the previous slide called Preventing Public Participation. Now, the administration is pushing this good cause exception well beyond its traditional limits. And it's done so in a couple of different ways. So first, agencies are invoking it along the lines that Jack suggested for rules that the agency considers unlawful, on the theory that public comment on an unlawful rule would be unnecessary. But as Jack discussed, there's often much to discuss about legality, about lawful alternatives, or about reliance interests. So this is very much an aggressive deployment of the exception. The second way that the administration has pushed on this exception is by invoking presidential directives. Again, we heard a little bit about this earlier, but courts have indicated, and indeed held in many contexts, that the president can't just supersede statutory requirements in the Administrative Procedure Act that apply to agencies. So some of these invocations of good cause are likely on shaky legal footing. The various subject matter exceptions are more targeted and have been deployed more narrowly. But again, the administration has stretched them, sometimes in legally questionable ways. So I'll start with foreign affairs. The APA exempts from notice and comment rules that, quote, involve, unquote, a military or foreign affairs function. Traditionally, this has been the kinds of things that, on a sort of intuitive level, you might think of as foreign affairs. But the administration has tried to extend this exception to apply to rules governing foreign nationals living in the interior of the United States. So, for example, rules concerning work authorizations or visas. This application of the foreign affairs exception to rules that affect foreign nationals is debatable at best, and there is, again, judicial precedent cutting against the administration's general interpretation of this exception. Then next, there's the statutory exception for rules, quote, relating to government grants, contracts, loans, and benefits. The most striking invocation of this exception has been when the administration rescinded rules relating to the non-discrimination requirements for recipients of federal funds under Title VI of the Civil Rights Act. Now, the way the courts have dealt with these issues previously, they've basically said, are you really doing substantive law when you make these rules, or are you governing federal funding programs? And so if courts hew to that traditional interpretation, again, it's hard to see how the administration's invocation of that exception would be lawful. So third, and finally, among these subject matter exceptions, the administration has invoked the exception for agency organization, procedure, or practice, for example, to rescind regulations concerning how environmental impact assessments are done under NEPA, the National Environmental Policy Act. The claim, roughly speaking, is that if you have rules about what agency officials should be analyzing, what kinds of things they should be considering, then that's agency procedure. But again, as many of you will be familiar with, NEPA has serious substantive implications. And so treating these rules as housekeeping arguably mischaracterizes what they're all about and what they should be for. Finally, and on a somewhat different footing, are shorter comment periods. So the norm, which was codified in executive order, was 60-day comment periods on rules that were subject to this process. And in some cases, courts have indicated that the APA actually requires 30 days so that the public can meaningfully participate. And again, the administration has been testing these limits, sometimes having comment periods far shorter than even 30 days, let alone 60. So the through line across all of this is that the administration has been seeming to treat procedural requirements as obstacles to deregulation rather than as legitimate constraints on agency power or as part of the process of informing government decision-making. And courts have historically been skeptical when administrations have tried to do even part of that. The administration is now doing this on a new scale. And I think it's worth stepping back to note that the notice and comment procedures exist in part so that agencies can avoid some of the substantive problems that my colleagues have been discussing. Comments help inform the agency about what the legal and factual issues are, what the reliance interests might be, what the alternatives to full rescission of a rule might be. And bypassing that process doesn't just create procedural problems for the agencies, although it certainly does that. It also produces rules that are likely to be substantively weaker and harder to defend in court on the merits because the agency hasn't had to engage with the best arguments on the other side. Now I will turn it over to my colleague, our regulatory policy director, Jason Schwartz, to discuss a different deregulatory tactic, sunsetting.
Thanks so much, Gabe. And hello, everyone. It's really wonderful to see so many familiar names along with new names in the participant list. I'm just making sure my video's working. Hopefully it is. So every White House since President Carter has done some kind of retrospective review of existing rules, and this administration is certainly no exception. They've had their share of more run-of-the-mill reviews. We've seen the Department of Interior and many other agencies call on regulated entities for ideas about rules to repeal. There's even a deregulatory suggestion box on regulations.gov. The FCC has perhaps taken this the furthest with its delete, delete, delete docket, through which it has repealed dozens of individual rules. But really, for the most part, even when agencies might be repealing a few rules at once through a single notice, these are mostly routine kinds of retrospective reviews, and they raise a lot of the issues that my colleagues have been discussing, like good cause, but they don't really raise any special new issues relating to regular retrospective review or sunsets. But then we have sunsets, which are kind of retrospective review on steroids. And through sunsets, agencies broadly set deadlines by which whole swaths of their regulatory regimes must be reviewed and affirmatively reapproved, or else the rules will automatically all be repealed. So the Trump administration sort of first dipped their toes into the sunset pool with some executive orders and memos calling on DOGE to try to spur broader deregulation. But then they really dove in headfirst when Trump issued Executive Order 14270. That order is called the the zero-based regulatory budgeting order because it borrows the accounting concept of zeroing out your regulatory budget every year and starting just from a totally blank slate. Um, the order says its goal, what it's about, is unleashing American energy supply and freeing that from the burdens of red tape. But it's really much broader than that. It covers 11 different agencies and all of their rules under some 22 statutes and tells the agencies that they need to sunset all of their existing rules under those statutory provisions within 1 year. And also for any new rules, build in a 5 year sunset period. So far, most agencies have missed these deadlines. We haven't even seen initial actions from the vast majority of them. Only FERC and NRC have actually finalized sunsets under this order, and really for just a small sliver of the rules that are ostensibly covered in the executive order. And those rules that have been sunsetted have ranged from, frankly, kind of pointless actions like repealing obsolete definitions to the truly absurd examples like NRC proposing to repeal its requirement for nuclear facilities to assess the risk of aircraft impacts before they ultimately backed away from that and didn't finalize it after public comments pointed out that that seemed like kind of an important rule to keep. And to the ultimately kind of surreal, like NRC again, in the name of speeding up energy permitting, actually repealing a rule that would have provided for fast track hearings. So the opposite of speeding things up. Um, but, it remains to be seen if other agencies are going to get around to following the executive order's aggressive requirements as written. But if and when they do, that will raise some serious legal questions that we will explore on the next slide. So first, even if all an agency is doing is adding language to an existing rule that says, this rule expires unless we reaffirm it within a year, that's still a rule under the Administrative Procedure Act. And so the classic state farm factors for arbitrary and capricious judicial review are still going to apply. So what does that mean? What are the legal issues that raises? Well, first, agencies are going to need to explain how these sunsets are not just following an executive order's preferences, but are actually consistent with their statutory text and the factors that Congress intended for them to consider, which can be quite challenging when the statute requires the agency to have a rule in place, how to explain then that the statute envisions you completely getting rid of that rule within a year. And it's especially tricky when the statute might, as many statutes do, already provide for a process for regular regulatory amendments and updates. Second, agencies are going to need to show that they are considering all important aspects of the problem. And so that includes reliance interests. That includes what's changed, if anything, in the costs and the benefits that were considered when the rule was first issued, when for most of these major or significant rules, an agency will have conducted an analysis and determined that the rule was benefit cost justified. Um, so if an agency is going to sunset, as the executive order envisions, dozens, a dozen, 2 dozen rules at a time, um, um, sorry, they're basically going to need to reassess the costs and the benefits of each of those dozen or 2 dozen rules, which is really a tall order for agencies that often struggle to complete even, one set of regulatory analysis for one rule at a time. On top of that, agencies are going to need to explain why 1-year sunsets are the right tool to spur energy production in light of the evidence actually before them. Why not a different sunset period or a different review process or a focus on a different set of regulatory changes? Why does the evidence on the effects of regulation on energy production support mass sunsets instead of some other reasonable alternative? And like my colleagues have discussed, agencies are required to consider reasonable alternatives. Finally, sunsets are going to need to follow required procedures, including providing meaningful notice and comment, as Gabe just explained. Now, the wrinkle is here, the executive order does remind agencies and push them to, well, you should at least take comments at some point before the rule is ultimately sunsetted in the future. But even if an agency does that and sets up a future comment period, that doesn't cure a failure to take comment now when the agency is issuing the rule that adds the conditional sunset timeline in the first place. So there are a host of legal concerns that will come up if agencies do implement the executive order according to the really quite ambitious requirements as written. So, we're planning to continue to wait and see how that happens and how the agencies will try to overcome those legal challenges in the future. But for now, I'll hand it over to Max to discuss the litigation landscape.
Great, thanks so much, Jason. And I will just plug one more reminder. I'm the last presenter here. So if anyone has additional questions they'd like to ask, put them into the chat, and time permitting, we'll get to them in the remainder of the session. So to wrap up, I'll briefly look at the litigation landscape, what courts are doing with Trump administration actions, and what it means for potential future challenges to deregulatory rules. So according to the litigation tracker from our colleagues at Just Security here at NYU School of Law, there have been 330 federal court challenges to Trump administration actions that have resulted in decisions thus far. And plaintiffs so far have won nearly 2/3 of those cases, with 217 decisions blocking the government's action, either on an interim or a final basis. And courts are ruling against the Trump administration actions for a wide variety of reasons, including violating statutory limits, skipping required procedures, and acting arbitrarily. And in fact, as of November, courts have struck down 68 executive actions from this administration as arbitrary capricious. Again, that's according to Just Security. To be clear, the vast majority of these decisions are in the context of non-rulemaking actions, such as terminations of immigration designations, withdrawals or denials of federal grants and permits, and restructures of federal agencies. But as more rulemakings are finalized, these early cases give useful hints about how courts will treat rules that dismantle or narrow existing regulatory programs. And I'll discuss a few of those nuggets here. So across recent cases, this is on the next slide, courts have hammered three of the key points that have anchored this webinar. One, the need to provide a reasoned explanation. Two, the need to provide clear justification when changing course, including consideration of reliance interests and alternatives. And three, fidelity to the best reading of the statute and judicial precedent. And in recent years, the Supreme Court and other federal courts have struck down numerous agency actions for failure to provide a reasoned explanation, which includes actions from the first Trump administration, such as the DACA rescission and the attempt to add an immigration question to the census. In the DACA opinion, which my colleague Jack noted earlier, Regents versus the Regents case, the Supreme Court reemphasized that when repealing an existing regulatory program, agencies must consider reliance interests and alternatives short of full repeal. And in 2024, the Supreme Court in Ohio v. EPA reemphasized that agencies must closely consider public comments and provide a full justification for all components of their regulatory action. Matt, switching to the next slide. So following this lead, courts have subjected actions from the current Trump administration to close scrutiny. First, courts are not accepting bare invocations of presidential authority or vague factual claims as a substitute for reasoned explanation. As an example of this, I'll discuss litigation over the Trump administration's rescissions of offshore wind permits and stop work orders halting offshore construction. So in a nutshell, the Department of the Interior has issued a series of orders in recent months that halt wind energy approvals. And in doing so, they've typically cited the president's executive prerogatives and various unspecified national security concerns. And now, following a number of cases that were filed, 5 different courts have blocked those orders, all as arbitrary and capricious, finding that Interior failed to provide a reasoned explanation for deviating from its prior approvals. And in one of those cases, in fact, a judge from the DC District Court, who was appointed by President Reagan, called the government's action the height of arbitrary and capricious review. Other decisions have explained that the president's command do not supply a legal rationale for agency actions and have rejected the government's vague national security concerns. Now, to be clear, these decisions were made relatively simple by the government's bare bones rationales for its decisions. However, they still demonstrate that judges will scrutinize agency rationales and will not accept conclusory, contradictory, or unreasoned justifications, as my colleagues Bridget, Kate, and Dina all talked about. And one of the key points here is that the president told us it's not by itself a reasoned agency justification, nor a bare bones conclusory allegations. Agencies have to justify their actions with clear explanations that courts will scrutinize. Courts are also closely scrutinizing attempts to bypass notice and comment under the good cause exception, as my colleague Gabe talked about. So for instance, in September, the Department of Transportation issued a regulation that narrowed the authority of states to issue commercial driver's licenses to certain non-citizens. And citing public safety concerns as the basis for invoking good cause, the agency did not take pre-publication comment on the rule. But just a few weeks later, last November, the DC Circuit stayed the rule, finding the department's public safety concerns were not supported by the agency's limited analysis. And once again, this case exemplifies that courts are subjecting agency rationales to close scrutiny and are not accepting poorly reasoned or unsupported explanations. So agencies can try to move fast, but they need to give serious evidence and analysis to justify skipping comment. Notably, however, litigation over uses of the good cause exception could quickly become moot if the agency takes and swiftly responds to post-publication comments, as has now happened as of last week with that truck rule. There are, of course, some limits to these requirements. So late last year, in a case called Trump versus Orr, the Supreme Court clarified that the Administrative Procedure Act does not require a detailed justification when the statute commands the agency to follow the president's directives. And in another Supreme Court case from last year called 7 County Infrastructure versus Eagle County, the Supreme Court emphasized that reasoned decision-making is satisfied when the agency performs extensive analysis and reasonably explains its decision, even if there may have been some analytical gaps in the agency's analysis. So as agencies finalize more regulations with supporting analysis, courts will have to decide the boundaries of the arbitrary and capricious standard in particular cases. And finally, after Loper-Bright in 2024, as my colleague Jack discussed, courts are no longer deferring to agencies on ambiguous statutes. They are choosing what they view as the best reading. Just last week, for instance, the Supreme Court held that the International Emergency Economic Powers Act does not authorize the president to impose global tariffs, finding that the statute's specific language does not authorize this novel action. And as agencies finalize more regulations that interpret statutes in new and often unprecedentedly narrow ways, courts will increasingly grapple with similar types of interpretive questions. So with that, I will turn it back to my colleague, Martha.
So without further ado, we only have a short amount of time, so I'll just turn to Q&A. I will read some of the questions that we received in the chat and toss the question to one of my colleagues. So one of the questions we got was, could litigation potentially target the legality of White House orders that direct agencies to bypass public comment? Or would cases need to focus on individual agency actions that do so? So Gabe, would you be able to jump in on this one?
Certainly, Martha. That's a great question because we have seen so much litigation already under this administration against presidential orders of various sorts. So we can think of the tariffs case that came out so recently where the president himself imposed tariffs. But with respect to the kinds of issues that I discussed and about bypassing notice and comment, the short answer is probably no. We are not going to see litigation, and we could not see probably litigation directly against executive orders directing agencies to bypass notice and comment. There are several reasons for that. One is that the orders by their own terms are not legally binding and do not create legal rights. So they actually contain, as many executive orders do, kind of boilerplate language saying this doesn't create any enforceable rights. Another is that there are various doctrines of justiciability, which go under the names of standing and ripeness. But basically, there has to be a kind of concrete dispute before the courts are going to get involved in the litigation. And then finally, behind all this is something in the Administrative Procedure Act itself, which is that it only applies by its terms to agencies. And the Supreme Court has held that the president is not an agency for purposes of that statute. So many of the rules that we've been discussing on this webinar would not apply to the president, or to the extent they did apply, it would be in a very different legal form. But it's an excellent question.
Another question we got a question asking for clarification of what is meant by zeroing out the regulatory budget each year. And just asking if we could please explain what is the regulatory budget. Jason, do you want to dive in on this one?
Yeah, thanks, Martha, and thanks for that question. I know I kind of glided over that quickly. So in the world of accounting, my understanding is that some organizations like to start their budget each year from last year's budget. And they start from there and they say, okay, what are our new needs and expectations? And we'll tweak based on last year's budget. Zero-based accounting is instead, you start from zero. And everything in your budget, you have to re-justify each year. So this sort of radical form of sunsetting is borrowing that approach, bringing it into the world of regulations and saying, what if instead of saying, well, we have an existing set of laws and we're going to make modifications as necessary, we get rid of everything in, say, a year, and then we have to re-justify any new rule that we want. You know, in the extreme form as written, you know, this would cover, you know, really fundamental things like, you know, 50 years ago, NRC adopted a rule that said this is the symbol for like dangerous radiation, the classic kind of, triangle symbol. We would get rid of that rule. Rules that really like businesses rely on. Um, in terms of what a regulatory budget is, here they're kind of using the term loosely, but Trump did also early in the term issue an executive order that did set a regulatory budget and basically told agencies, if you're doing a new rule, first you have to repeal 10 rules for every new rule. And then also, if that new rule has costs, you have to repeal something that saves as much money as you're imposing in new costs, not considering any benefits, just considering the costs and kind of asking agencies to set their own, regulatory budget for how much costs they're going to um, impose on people, again, without considering any of the benefits. So that is regulatory budgeting.
Great. Thank you so much, Jason. And another question. We are getting down to time, but here we have what factors have courts used to decide whether a comment period was long enough to provide a meaningful opportunity to comment? Jack, can I toss that one to you?
Yeah, there's not a super clear answer on this. The Administrative Procedure Act does not set like a minimum number of days that comment needs to be available for. Where courts have engaged with this, they have often recognized 30 days as a sort of general minimum. But the general rule of thumb here is just that there's an adequate opportunity for the public to comment given the context and complexity of the rule.
Okay, great. And Bridget, can you grab the next question? How many alternatives does an agency have to consider? Did the Supreme Court ruling in the cross-state air pollution case raise the bar on the number or detail of alternatives agencies must consider?
Sure, I can talk about that a bit. So there's not like a specific number of alternatives that an agency needs to consider. The rule is that it needs to consider reasonable and obvious alternatives. So for a rollback, that might mean a partial rollback. In the cross-state air pollution case, so Ohio v. EPA, that's touching on a similar issue to alternatives analysis, but slightly different. So in that case, the Supreme Court upheld a preliminary injunction against EPA's Good Neighbor rule, which was about, as per the title, cross-state air pollution. So pollution that originates in one state and goes into another, on the grounds that the rule would likely eventually be found arbitrary and capricious. Plaintiffs argued, and the court agreed, that EPA was obligated to have considered what would happen if, related litigation, not unrelated litigation, only some states were actually ultimately covered by the rule. So this rule covered 23 states. Some of those states might fall out of the coverage of this rule. The agency, according to the court, was supposed to consider, so if there's only a subset of states, what happens? This puts EPA in potentially a bit of a bind because or any agency, because not only does the agency need to make sure its rule meets all the requirements of the APA, it also needs to make sure that if part of the rule doesn't meet APA requirements, that the rest of the rule can stand. So a way an agency can do this is through a severability analysis. So in a severability analysis, an agency explains that even if one section of a rule gets struck down by a court, the other sections are justified on their own merit and should continue to operate. In Ohio v. EPA, the Supreme Court said EPA severability analysis was lacking. But ways an agency could buttress its severability analysis would include providing support for each independent aspect of the rule, in terms of cost-benefit justification, in terms of statutory justification, et cetera, to show that the whole framework holds, even if one or more pieces get taken away.
Wonderful. Thank you so much, Bridget. We are at time, so I will just close by saying thank you so much for everyone's attention and interest in these issues. Please do look out for the emails that have come or will be coming with the CLE affirmation form. The emails will also have links to relevant resources, most importantly, the issue briefs that describe some of the topics that, or all of the topics that we discussed today in greater detail. So please do look out for that. And if you miss those, you can find those resources at policyintegrity.org as well. So thank you all again for your attention. We greatly appreciate it, and I hope you all have a wonderful rest of your day.